LB 367 violates the First Amendment. It invades the counselor-patient relationship to dictate what can and cannot be said. It forbids certain speech based on its content and its viewpoint. The Supreme Court has repeatedly held that restricting speech because of its content or viewpoint is almost never permissible. Lower federal courts have struck down laws virtually identical to LB 367. For example, in a case called Otto versus City of Boca Raton, the U.S. Court of Appeals for the 11th Circuit struck down 2 local counseling censorship ordinances because they violate the free speech clause of the First Amendment. Now, it is true that 2 appellate courts have rejected free speech challenges to counseling censorship laws similar to LB 367. But these courts embrace the rather odd notion that when counselors are speaking to their patients, they are not actually engaged in speech. These courts declared that when counselors are speaking to their patients, they are instead engaged in conduct. By slapping the label conduct on what is clearly speech, these courts evaded the correct legal test that judges apply to content-based restrictions on speech. When courts apply the correct test, called strict scrutiny, they almost always strike down the law in question. This unusual and incorrect approach did get the attention of the U.S. Supreme Court. In a case called Chiles v. Salazar, the court has agreed to review one of these erroneous decisions, and it will hear arguments in the fall. When a law forbids speech based on its content or viewpoint, something that LB 367 clearly does, the correct judicial approach is to analyze whether the regulation is the least restrictive means of achieving a compelling governmental interest. This approach, again, is called strict scrutiny. LB 367 would not survive strict scrutiny. Now, to be sure, protecting children is an important governmental interest. But as the 11th Circuit observed, the evidence that talk therapy harms children is weak. The APA found that, quote, no clear indication of the prevalence of harmful outcomes among people who have undergone talk therapy regarding sexual identity and attractions. One final point. There is increasing evidence that counseling censorship laws like LB 367 harm children. These laws inevitably channel gender-diffused children into so-called gender-affirming care. This puts them on a pathway that usually includes puberty blockers, cross-sex hormones, surgeries, and a lifetime of challenging, expensive medical and mental health care. This is particularly unfortunate given that the vast majority of children confused about their sexual identity will come to accept their bodies by simply going through puberty.